Welcome to UIA Podcast, where our members and member firms address important legal issues of the day. We hope you will enjoy today's edition. Thank you. Hello, everybody. This is Jerry Roth, President of the UIA. Thank you for being here with us today. We have another contribution to the UIA podcast series. We are delighted today to be presenting a podcast regarding the issue of U.S. economic sanctions, the regime we have in the United States, the related laws and regulations. And this is a topic that has been very much in the news media lately. We're going to hear about it from our participants who are both from a law firm that is a UIAdvance member, I'm happy to say, Seward Kissel, located on the East Coast of the United States. We're going to hear from Bruce Paulsen and Hoyoon, who are going to tell us about the basics of the U.S. sanctions systems, as well as some of the more nuanced implications and recent developments. So welcome, Hoyoon and Bruce. I'm really glad to have you here. Could you each introduce yourself, and let's start with Hoyoon.
Thanks, Jerry. My name is Hoyoon Nam. I am a partner at Seward Kissel. Just to tell you a little bit about our firm, we are a full-service law firm headquartered in New York City. We have one other office, which is in Washington, D.C. We're about 160 lawyers, all in the United States. We're probably best known for our investment management practice. We're accredited to have formed the first ever hedge fund back in 1949 and remain very active in the asset management industry. We're also one of the go-to law firms in the shipping industry. We've taken public an overwhelming majority of the shipping companies that are traded on stock exchanges now. We've worked on some of the largest shipping company mergers in the past few years. We're very active in the ship finance world, which is what I specialize in. I do a lot of work with financial institutions all around the world on their financing matters, and that includes plain vanilla secured bank loans, large syndicated loans, unsecured bonds, and more structured products like receivables financing or leasing. Because I work a lot with ships, I'm qualified to practice law in the Marshall Islands, which is one of the most popular jurisdictions for ship registration. And I work with shipping companies that are formed there on regulatory and corporate governance issues arising in that jurisdiction. Seward Kissel also has a very active litigation and regulatory practice, which Bruce can talk more about.
Bruce, how about you?
Thank you, Hoyoon and Jerry. Glad to be with you today. As Hoyoon mentioned, we have certain industry focuses at the firm, including, among others, investment management and shipping. And these are two areas that are hard hit by the U.S. international sanctions regime. I co-chair our litigation group, and I run the international sanctions team. And we've been advising on the sanctions space for really quite some time. Just a little bit about sanctions. They are a blunt foreign policy instrument that has been utilized for the United States for nearly the entire time the Union has been in existence. But people think of sanctions, they think more recently. And when they think sanctions, and historically, you think of primarily Cuba, Iran, North Korea. Cuba is perhaps the archetypal sanctions regime. It is a regime where U.S. persons are prohibited from doing business. It's a near total embargo with Cuba. There was some softening under the Obama administration, and that has been largely reversed in the Trump administration. But when we talk about Cuba and when we talk about Iran post-1979 revolution, we're talking about primary sanctions. These are sanctions where U.S. persons, which is defined in a number of different ways in different sanctions regimes, but primarily refers to U.S. citizens, U.S. corporations, including foreign branches, and any person or entity within the U.S. And with Iran and Cuba, U.S. persons can't do business with those countries or their citizens. So that is a primary sanction. It's an embargo. Secondary sanctions are a more recent development, starting with Libya in the 1990s and primarily with Iran about 10 years ago with the Comprehensive Iran Sanctions and Divestiture Act of 2010. Secondary sanctions are an attempt by the U.S. government to legislate extraterritorially. Essentially, secondary sanctions prevent non-U.S. persons from doing business in certain jurisdictions. And the way the U.S. can do this to actually impose a meaningful sanction on a foreign company is by using the Office of Foreign Asset Control, or OFAC, which is a division of the Treasury Department, which has control over the flow of the US dollar. Under the 2010 Act, which I'll call CISADA, foreign companies taking, for instance, crude oil from Iran or bringing refined petroleum products into Iran and now in some other different industry sectors in Iran could be sanctioned by being frozen out of doing business in the US dollar. The US dollar is the reserve currency of the petroleum industry as well as the shipping industry. So it's a significant sanction. So that's secondary sanctions. The third is sectoral sanctions. And this came with the 2014 incursion of Russia into Ukraine. And essentially, it's a little bit different than secondary sanctions in that it targets particular industry sectors like Arctic oil exploration or the defense industry in Russia. So those are the three types of sanctions. If you can remember those three, primary, secondary, and sectoral, you will understand how our sanctions regimes work.
Thanks. That is a really helpful discussion. Can you, before we go on, can you just give us some examples? You've mentioned a few of countries that are subject of these three types, the primary, secondary, and sectoral sanctions, in addition to Cuba? Yeah.
There are comprehensive sanctions regimes like Crimea, Cuba, Iran, North Korea, and Syria. And then there are other notable sanctions regimes, and there's a new one on this list. The big one and most hot area over the last couple of years has been Venezuela, Russia with sectoral sanctions, and now where we have Hong Kong, which has some direct sanctions as well as a sort of secondary sanction regime.
Okay, so this has broad effect and can affect business in ways we might not have anticipated. Hoyoon, you said you were a banking and finance lawyer primarily. How does this come? How did the issue of sanction laws come up in your practice?
Yeah, so sanctions laws are a sensitive and challenging area for banks. As Bruce mentions, sanctions is really a political tool to cut off somebody's cash flow. Whether that's an individual or a country as a whole. And the banking system inevitably plays a role, an important one, because the banks are usually the medium in that process. As you may know, Jerry, many large banks have an entire department dedicated to ensure compliance with sanctions. And given the current political climate, the level of attention on this from banks' internal perspectives is probably going to get even more heightened. But more specifically, as a lending lawyer, I deal with sanctions a lot, often with the help of Bruce and his colleagues. Negotiating provisions in a financing agreement dealing with sanctions can be tricky sometimes, because on one hand, you have a bank who would never ever want to be caught in a situation where the proceeds of their loan are used by somebody who's sanctioned, or even indirectly. So banks insist upon airtight protections there. But on the other hand, you have a borrower who may be a perfectly law-complying business entity without any connection to US economic sanctions whatsoever, but they're presented with these contractual provisions in a loan agreement that are sometimes impossible to comply with. And as we mentioned before, we do a lot of work for shipping companies, and this is an even bigger issue for them, because by its nature, a shipping company deals with people and companies all around the world. And they need to be extremely vigilant. Not only do they need to worry about their own ships going to certain places, they need to worry about their customers that use those ships. And in some cases, they have to worry about customers of those customers that may be on the sanctions list.
So if a bank is trying to sort of protect itself from liability, how does it deal with that? And what are the steps it can take to sort of deal with this very scary, what sounds to me like scary liability potential?
Yeah, it is a big issue for banks, and as mentioned, they have a whole. Many of them have a whole department dedicated to ensure compliance with sanctions. And banks have been putting in extensive contractual provisions and financing agreements. Whether that's reps and warranties, covenants, events of default, and some kind of reporting covenant, so that they can ask for information from their borrowers. They have a lot of rights under their financing agreements to act upon. However, these contractual provisions can sometimes only do so much because banks still don't control their customers, and they have to rely on their customers to do the right thing and provide the right accurate information. So at the end of the day, it really falls on the banks themselves to do their diligence through KYC or other independent verification methods to check off any risk involving sanctions violations by their customers. And this is one of the reasons why it sometimes is such an involved process to even open a bank account here in the United States. And some of our foreign clients are surprised how time consuming that can be.
I just thought I'd throw in a comment that the banking area is very complicated, as Hoyoon mentioned, and we had a recent matter involving an international bank that had a borrower which they of course have done all their KYC and due diligence on prior to making the loan, that was very publicly sanctioned earlier this year. This triggers all sorts of covenant and contractual issues, throughout the bank, and may involve a possible self-disclosure to OFAC when there's been a violation. So there's a ripple effect for any kind of sanctions violation triggered, say, again, by a borrower, sometimes perhaps even unwittingly. The sanctions regimes are strict liability regimes, so you can get in sanctions trouble without intending to do so. And it creates tremendous compliance headaches for banks.
Well, it's so interesting. I know you've alluded to this, but I want to come back to a point, that was made earlier, Bruce. I think you pointed out, even a company, a lot of our listeners are, as part of the UIA, are outside of the United States. And so even a company or an individual outside the United States needs to worry about these issues, I know. And I've had that experience in my own practice, but it's surprising and it's hard to understand exactly how that's the case. Can you talk a little bit more about why, let's say, if I'm a French company doing business in Europe with a German company, let's say, within the EU even, why do I have to comply with the United States laws in that instance? How do they even apply to me? Hoyoon, is that something that, you could start with, and then we'll...
Yeah, I guess I'll start with, and Bruce can chime in. I think this has been mentioned before, given that the US dollar effectively functions as a currency for global trade in many cases, unless your business is really, well insulated within your geographical boundaries using your local currency only, companies likely have to deal with the US banking system. If you're doing business in US dollars, dollars will have to involve US banks at some point. And that's one of the reasons why even without apparent connections to the U.S., some companies will find themselves needing to comply with the U.S. sanctions regime. And as you say, Jerry, this sometimes is a surprising result for some companies, and that's why it's important to understand your obligations under U.S. law.
Bruce, yeah, go ahead, please.
Sure, I can add to that. Again, OFAC's power is over the U.S. dollar, and if you are doing business in the U.S. dollar, whatever business you're in whatever part of the globe, that doesn't make you subject to U.S. jurisdiction, but it does make you subject to OFAC's control over the flow of U.S. dollars. OFAC promulgates a software package called, colloquially, the OFAC filter, that every bank that processes U.S. dollar transactions has. It is a names-based computer system that has the names of companies and individuals who, for instance, are on the specially designated nationals list, the SDN list. That's the list of persons that U.S. persons cannot do business with, as well as sanctioned nations and corporate entities and so forth. So if you are a foreign company, that French company doing business with a German company that happens to have some dealings with Iran that run afoul of CISADA, the statute I mentioned earlier in the program, if there's an issue, OFAC can add your name to the OFAC filter and you can no longer transfer US dollars, which is a significant sanction.
Huh. I have to say, this is going to be of great interest to our out-of-country listeners, but what will also be of interest to them is, okay, what happens if they screw up? What happens if a company ends up, whether intentionally or unintentionally, which sounds very possible here, violating the sanctions law? Who comes after them? What should they expect? Who should they expect to hear from, and what penalties do they face?
Again, in many instances, and certainly for U.S. persons, OFAC or the OFAC sanctions are a strict liability regime. If you've triggered a secondary sanction, it's a little bit different, but the choice is the same. You realize perhaps the sanctions have been triggered. You may realize that yourselves, or you may get contacted by OFAC. But OFAC favors what's called voluntary self-disclosure, and you have an automatic reduction in any kind of penalty if you come forward voluntarily and you're the first in. OFAC, like many other government agencies, will assist further, and it's a fairly user-friendly agency, but you're going to get more cooperation and a lesser penalty from OFAC, one, if you self-disclose, and two, if you cooperate with the process.
What about for individuals beyond companies? If I'm an employee of a company that's engaged in this, do I have to worry about this? Do I have any liability? Can I go to jail? Do I have to pay a fine?
Yeah, and there are significant sanctions depending on the regime. For instance, we get very few calls from companies saying, hey, can we do this transaction with North Korea? Because essentially legitimate corporations don't do that business. But let's say you're the US board member of a foreign corporation that otherwise has no ties to the United States and does international business that may offend US sanctions regimes. As an individual, you need to think hard about the exposure you might have if that company does business with the wrong country or the wrong entities. So yes, there are individual risks, but they're primarily on U.S. executives, board members, and so forth.
Wow, that is, again, quite scary. Okay, well, so those are the general rules. What's happening lately? I know that sanctions laws have been in the news lately. We read about it from time to time. I think we've seen things referencing China, but maybe I'm getting it wrong. Bruce, what's happening these days? Where do we see the action, so to speak?
Yeah, if you want to go back a little bit further than this summer, a lot of the activity has been on the Venezuelan front. starting with January of 2019, when OFAC added PDVSA, the state-owned oil company of Venezuela, to the SDN list, which made it, toxic for U.S. persons to do business with. They're also been clamping down on shipments to and from Venezuela, including seizing ships at sea this summer. This also impacts people in the investment management business who, say, for instance, hold Venezuelan debt or PDVSA debt. So there are a lot of issues surrounding Venezuela. The foreign policy of the United States is to crack down on the Maduro regime, and that continues. But the most recent developments in this space were probably primarily on July 14th, when President Trump signed the Hong Kong Autonomy Act, which enacted additional sanctions against the People's Republic of China for actions relating to Hong Kong's autonomy. And President Trump also issued an executive order the same day recognizing that Hong Kong is no longer sufficiently autonomous to receive certain preferential treatment from the United States under U.S. law. And there's a sort of secondary sanctions regime that comes under the executive order, which against non-U.S. persons that have materially assisted, and material assistance is a concept that is rife throughout our sanctions law. Materially assisted, sponsored, or provided financial or technological support for goods or services to any person who has otherwise been sanctioned. So, for instance, if you have 11 PRC citizens, including Carrie Lam, were sanctioned on August 7th, if you are a U.S. or a foreign financial institution where any of those individuals bank, you may have a sanctions problem. So there's been a lot of developments in China, and most recently, sanctions against TikTok and WeChat. This again was in August. These sanctions, interestingly, are not administered by OFAC, but by the Department of Commerce. For instance, with respect to TikTok, the August 7th executive order prohibits any transaction by a U.S. company or individual with respect to TikTok's apparent ByteDance. Okay, what's any transaction? Same with WeChat. The executive order prohibits any transaction that is related to WeChat by a U.S. company or individual. Millions and millions of people have the TikTok and WeChat apps on their phones. We expect that there will be some guidance from the Department of Commerce. People have until, I think it's October 1st, to wind down transactions with these entities. And obviously there's a scramble with respect to some sort of transaction with TikTok and a U.S. company. But it's very hard to know what you can do and what you can't do. And just a brief comment, U.S. sanctions laws are couched in ambiguity. They're a little bit different, say, than our securities laws. If you look at an SEC regulation, you can generally tell what the public company can or can't do. But because of terms, material assistance, any transaction, substantial transaction, what do these terms mean? A director of OFAC once said that a substantial transaction is anything the director of OFAC says it is. So the idea of ambiguity in this space is to keep people off balance and keep them out of regimes that the administration at the time disfavors.
Yeah, that is fascinating. As somebody who has traveled quite a bit in Asia and worked with many Asian companies and clients, you need to have WeChat or else you're not going to be able, for example, to communicate with your clients. That's how many of my clients communicate with me and with others. And so when you add to that the ambiguity of a phrase like material assistance and engaging in a substantial transaction, it really does raise a lot of questions that we'll all need to keep tracking. Hoyoon, how about you from the banking perspective? Is there anything new with in that regard?
Yeah, I'm spending more and more time negotiating these sanctions-related provisions in a loan agreement. I'm seeing that banks are getting even more stringent about their KYC requirements and insisting upon these protective provisions in their contracts. And I think that trend is going to hold for the foreseeable future, as we discussed. One thing that I wanted to mention before, when Bruce mentioned Venezuela, was that, and this is something unique to the transportation industry, but vessels and aircraft and other objects can be specifically sanctioned. So for example, a number of ships were specifically named for sanctions purposes for carrying oil to Venezuela or from Venezuela recently. You normally wouldn't think that an object can be the target of a law, but ships and aircraft can be treated like a legal person in this respect. That's something interesting, but something also to look out for if you're in that industry.
So there really are three ways, if I understand it correctly, the government, the United States government, can come after you. One is against the company, one is against the individuals, and it sounds like there is a third way, which is against perhaps the vessel or the object that's at issue. And thereby captures a whole, in each instance, captures different entities or people or companies through those various means. Do I have that right?
Yeah, or their properties, vessels, aircraft, or other objects.
And so if you're doing business with Venezuela, you may take a hard look at the regs and say, well, I can do this deal and probably stay out of trouble. And if you're a foreign company, there's no secondary sanctions regime for Venezuela, but there is, as Hoyoon pointed out, designation risk, that you could be designated as an SDN. And if you're designated as an SDN, it wreaks havoc with business you do all over the world. Again, you become toxic. And it's much easier to get designated than it is to get delisted. OFAC will often move quickly if they think an entity or an object, such as a ship or an airplane, should be designated. There were a couple of instances this spring where a couple of ships were quickly delisted, but often it can take a great deal of time, and that entity becomes something that no one in the world will do business with. And so it's a substantial penalty and wreaks havoc in your business.
Well, listen, Bruce Paulsen and Hoyoon Nam of Seward Kissel in New York, I want to thank you. You've certainly given us a lot to think about. You've given entities both in the United States and clients in the United States, and especially relevant to us at UIA, lawyers in the United States and outside the United States, food for thought and a real caution that this is not an area they can ignore, that they need to be up to speed on it. They need to at least understand the basics and be able to perceive if and when there's an issue so that they can confer with folks with expertise in the area like both of you. So thank you very much. I appreciate your spending some time with us today. So do our UIA listeners. And for all of you out there, we will be back with an additional program to UIA podcast in the coming weeks and months. If you're listening to this and it's prior to October 28th, we hope you'll join us at our virtual Congress, October 28th, 29th, 30th, 2020, 3 days around the legal world. You'll hear from experts like Bruce and Hoyoon about a whole range of legal topics, as well as have the opportunity to enjoy social events, ceremonies that we normally have, as well as some surprises. So thank you both, and thank everybody else. And with that, we'll end up for the day. Thank you.